If you violate any condition of probation, then you'll be back in here on a motion to revoke your probation. You can be found guilty, which means you'll get the felony conviction. And then I can send you to prison anywhere in that length of time of the punishment range, which is between 2 years and up to 20 years in prison. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. This is cause number 26 DCCR 0072. Mr. Smith was previously in court, entered a plea of guilty to, just like that, to the second-degree felony offense of assault on a peace officer. We took that plea, reset the case for sentencing, and then Mr. Smith was not present for sentencing. I issued a bond forfeiture. The pre-sentence report was already done, and he was arrested, and we're back here now. And so I guess a couple of questions. One, Mr. Coleman, is the state still ready to proceed and go forward with sentencing?
We are, Judge, with the understanding that there is no agreement to the type or the length of probation.
Correct. And so the agreement was for a probation, but not agreed as to whether it was a deferred or a straight probation and the length of time on that probation. Have you both had an opportunity to review that pre-sentence report?
Yes, Your Honor.
The state has, Judge.
Any additions or corrections to that report?
None from the defense, Your Honor.
None from the state, Judge. If we could have just a brief brief argument, please.
Sure. Ms. Holmes, you may proceed.
Yes, Your Honor. And looking at the PSR report, it appears that all of the current pending matters all occurred on the same day, which is out of character, obviously, for Mr. Smith, who has no previous criminal history. He had no previous juvenile history. And so on this day, he was experiencing, he has been diagnosed with a few mental health situations such as bipolar disorder, ADHD. And I think a part of that is why he acted out on this particular day. He is aware that his actions have brought him here, and he is remorseful, and he knows that if given the opportunity on probation, he will abide by the rules and do what needs to be done to successfully complete probation. It's also important to see that they evaluated him at a low risk level, which means they feel that he is a probationer that would benefit from specialized programs with probation, as well as with the mental health services, and they don't feel that he would likely reoffend or be an issue on probation. So I believe that's very important for the court to see. Your Honor, we are asking that due to his lack of criminal history, that he be afforded the opportunity to be placed on deferred probation to show that he can abide by the rules. Obviously, we will be requesting that he be placed on a mental health caseload as well. To aid with that. And also he wants to get his GED. As the court can see, Mr. Smith has an 8th grade education and did not go to high school. And he does want to get his education and get his GED so that he can have gainful employment and help to provide for his family. And Your Honor, we are asking for deferred probation. The length of time, obviously, whatever the court deems necessary, but we do believe that deferred is the best for this situation.
Why didn't you come to court for sentencing?
I didn't have no transportation at the time, and I was sick.
Did you call your
I
bondsman?
called the bondsman. They said there was nothing they could do about it. I tried to get a hold of my lawyer, and she didn't answer. And I called the courthouse, and they said just try to come in later on that day. And I had no transportation. I have transportation now, though.
Mr. Coleman?
State will concede that the defendant has no criminal history. However, I think the probable cause affidavit doesn't do justice in describing what happened there, Judge, between this defendant and Sergeant Noah Visser. This was an all-out fight, Judge, and it went on for some time. This defendant struck Sergeant Visser in the face. It went on. They went to the ground. They went on for about at least a minute until backup units arrived and were able to assist. It's regrettable that I could not get Sergeant Visser here today so that I can enter into Yep, entering the evidence in play for you. The video of that incident, I suspect that the court would find it very probative as to what you would do. But it was an all-out fight, not like one of these deals where they're just wrestling and tussling and somebody kicks somebody or somebody elbows somebody. This was an all-out fight, Judge. In my opinion, that's what warrants or merits a straight post-conviction probation as opposed to a deferred judge.
Thank you, Mr. Coleman. I can just tell from the police version in here without seeing the video that this is different than a typical assault on a peace officer that we get where, like Mr. Coleman said, I mean, this, I don't know what was going on, but it also seems like it was very out of character. I agree with Miss Malfina, I mean, Miss Holmes, that something was obviously going on that day. What I'm going to do, Mr. Smith, I'm going to find that you entered your plea of guilty previously, freely, and voluntarily. I'm going to find sufficient evidence to find you guilty. I'm going to give you an opportunity today because I'm not going to find you guilty. I'm going to defer all proceedings, but I'm going to place you on probation for 10 years. So I had considered a straight probation with less time, but if I'm going to give you that opportunity for deferred, it's going to be a long probation. You do everything you're supposed to on this probation. There's no reason you couldn't even get off of it early, but it's going to make sure that we know that everything that you need is getting taken care of. I am going to order that as a $500 fine and order that you follow all of the rules and conditions of probation. That is going to include participating in any mental health care services through Spindletop. If they say you have to do something, even if you don't think you need it, it is now part of your probation. So you're required, if it's medication, if it's counseling, whatever. In addition, I'm going to order that you get your GED. I'm glad that you want to do that. It's not going to be easy since you stopped school so early, but it's still possible. You can do it. And now you're going to be required to do it because it helps everybody if you do that. So I'm going to order that you start that process within 45 days of today. So you don't get to wait and say, well, I've got 10 years to get my GED. I want you to get that GED because it's only going to help you do better in life. If you do everything you're supposed to in this case, this is the best opportunity of your life today to make some real big decisions that change your life because you don't have a felony conviction on your record. And if you're successful, the case will be dismissed at the end. You'll never have a felony conviction.
That's cool.
The other side, it's great because having a felony conviction changes everything. You can't get certain jobs, you can't live certain places, you can't vote, you can't have a firearm. I mean, the list is long on how bad having a felony conviction is. So you've got that opportunity today. Also, I'm sorry.
This.
Let me see the trial court certification. I just need to change the date. I'm going to handwrite it because that's from the other one. Also, I am making a finding. There was a previous bond forfeiture in this case dated April 28th of 2026. All right, you can go back with the bailiff. Good luck to, well, here, let me, hold on. There you go.
Thanks, Judge.
Thank you, Mr. Coleman. And then. So, Mr. Lewis and Mr. Smith, we've got that hearing on Herlin Romar. It's my understanding you guys have reached an agreement. Is that correct? Oh, where's Mr. Smith?
You just stepped outside.
Is there a sentencing on Herlin Romar over there? Carl Farrow? Ms. Collins?
I should put someone on the record. You're going.
Okay. Good morning. Are you Carl Farrow? This is 26 DCCR 0100. Mr. Farrow is charged with the state jail felony offense of unlawful possession of certain copper or brass material from October 30th of 2025. And what is the announcement?
Your Honor, if we can get a little bit more time, I've met with Mr. Farrow. This case involves whether he had authorization to possess these copper materials, and he's relayed to me that he does have documentation that had given him the authorization. And so if we could have some time so that he could get that to me.
Okay.
Yes.
All right. So I'm going to do a normal reset. Mr. Farrow, make sure whatever information you have, you get that, or your family or someone gets that to Ms. Holmes as quickly as possible so that she can then visit with Mr. Smith about it and then be back out to visit with you before that court date.
Thank you.
All right. You can go back with the bailiff. Donnie Smith.
Bond reduction?
What?
We got bond reduction?
This isn't how we communicate. It's for me because it's a bond forfeit.
Yeah, he
I
didn't
now have
go
to say out loud, and make certain findings if they've had previous bond forfeitures, if if they end up paying the sentencing. So I have to have them now look up that on everybody. Mm-mm. If they're really not really like leading up to the docket, then yes, you have to go back and look and they can tell you about that. Good morning. Are you Donnie Glenn Smith?
Yes, ma'am.
And this is cause number 26 DCCR 0072. Mr. Smith is charged with assault on a peace officer. And what is the announcement?
Well, Your Honor, he had previously pled, but he didn't appear for his sentencing.
Oh,
And so,
okay.
yes, ma'am. So we had done all that, but he didn't appear.
He pled, Judge, that there was no agreement as to the type of probation.
Do you
Or
have
The
a-
type and.
at the time.
Is there a PSI? It shows a status hearing, but I should have, it was set for sentencing and he didn't show up. And so there was a bond forfeiture. So I should have a PSI on Donnie Smith. It's not in the case.
I've got you.
No, because I'll have notes and,
Okay.
all right, just y'all can hold him for a few minutes. Let me, figure out where that is.
Yeah.
Mr. Lewis, you've got, Wacy Bork. There's no,
No, Judge, he informed me this morning that he's been able to try to retain somebody else, his own attorney.
thank you. Good morning. Are you Wacy Bork?
Yeah.
And this is 25 DCCR 1213. Mr. Bork is charged with the state felony offense. Excuse me, of theft of property. That indictment alleges 3 prior state jail felonies from different dates, which means for punishment purposes, this could be considered a 3rd-degree felony with a punishment range of between 2 years and up to 10 years. And Mr. Lewis, what is the announcement?
Judge, initially came in planning to place this on the trial docket, but after speaking with Mr. Bullock this morning, I guess after his conversation with his family, they'll be able to retain his own attorney.
Okay.
So I asked that he at least have that opportunity, at least one setting before the case is placed on the trial.
So, Mr. Bork, I'll reset your case in normal reset, which is about 30 days. Mr. Lewis is going to remain as your attorney, unless you get someone else hired. If you do, they'll file the appropriate paperwork to substitute in for him. If for some reason that doesn't happen before the next court date, then we'll need to go forward with you visiting with Mr. Lewis and see where we get on your case, okay?
Yes, ma'am. Can I ask a question?
What's that?
My time wouldn't go up. I mean, I should be able to get a lawyer, but my time wouldn't go up like I'm playing with you or nothing like that.
No, there's been no
Okay,
reduction.
The offer is what the offer is. It's probably,
Okay.
it's not going up or down at this point for any reason. If he wants to get his own attorney, he has that right. I'm not
Okay.
holding that against him.
Sure.
Thanks.
So that'll remain on the table. That's between y'all at this point. Once there's a rejection later in front of me, then things kind of change as far as accepting plea agreements later. But it sounds like Mr. Nichols is going to leave that on the table for you. Okay? All right, you can go back with the bailiff. Thank you, Mr. Nichols.
And Judge,
Yes.
while we have Mr. Nichols up here, we had the Antonio Riggs on the docket.
Uh-huh.
And before he's brought up, I wanted to speak with you about him. We definitely have a competency issue with him.
Just to fill you in, he was found competent back like in February.
Mm-hmm.
I've been, Mr. Lewis has informed me as he seems to have deteriorated some. I checked his jail screen. He has a history of seizures and things like that also affect him. So I think he probably
We need a new
Need-
evaluation.
Yeah, and his family's here. They've come and been speaking with me as was their interactions with him over this time. And
Okay.
he's definitely deteriorated, gotten worse.
Okay. I'll reset the case. If you'll make a notation for us to do the order for an evaluation on Mr. Riggs, please. And,
Yes, no.
and just make a notation. We could even do,
Sorry.
whichever one we didn't use. We've got other. Okay. Thanks. You can, we're gonna reset Mr. Riggs. And then you've got, Christopher Fair.
Yes.
Good morning. Are you Christopher Fair?
Yes, ma'am.
And this is 18-30684. Mr. Fair is on probation for indecency with a child by sexual contact. There's a motion to revoke that's been filed. And what is the announcement?
Judge, at this time, we're prepared to plead the truth for several violations.
Okay, just go through and set up a
Right.
hearing. Give me just a second. And will he waive the formal reading of that motion?
He does.
Mr. Fair, best you can, please raise your right hand. Do you swear or affirm the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yeah.
So, Mr. Fair, I have before me a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation December 2nd of 2019 for the second-degree felony offense of indecency with a child, and that was a 10-year deferred probation. Is that correct?
Yes.
It alleges that you violated your probation. Count one alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. And is that true or not true?
True.
Count two alleges that you failed to provide verification of performing the community service hours required. Is that true or not true?
True.
Count three alleges that you failed to successfully complete an approved sex offender treatment program by a licensed sex offender treatment provider. Is that true or not true?
True.
Count four alleges that you are behind in your court assessed fees as of December 9th, 2025 in the amount of $3,290. And is that true or not true?
True.
Count five alleges that you failed to immediately report to the probation officer your phone number, employment, and that you now have an email. And is that true or not true?
True.
Count six alleges that you failed to report by mail or online to the Jefferson County Probation Department for the months of February, March, May, June, July, August, September, October, November, and December of 2024. And then January, February, April, May, June, July, August, September, October, and November of 2025. Is that true or not true?
True.
Count seven alleges that you committed the new offense of possession of marijuana January 21st of 2026 in Walker County, Texas. Is that true or not true?
Not true.
Count eight alleges that you committed the offense of unlawful possession of a firearm by felon January 21st of 2026 in Walker County, Texas. Is that true or not true?
Not true.
Count nine alleges that you committed the offense of possession of drug paraphernalia January 21st of 2026 in Walker County, Texas. Is that true or not true?
True.
Count 10 alleges that you committed the offense of failure to drive in a single marked lane, January 21st of 2026. Is that true or not true?
Sure.
Count 11 alleges that you committed the offense of having no valid driver's license, January 21st of 2026. And is that true or not true?
Sure.
And count 12 alleges that you failed to immediately report to your probation officer that new arrest. Is that true or not true?
True.
Did you enter your pleas of true? See, the easier way to do this. Did you enter your pleas of true to all of the counts except 7 and 8 freely and voluntarily?
Yeah.
And did you plead true to those counts because they're actually true?
Yes.
All right, then I'm going to find that you entered your pleas of true to all of the counts except 7 and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. But I'm going to reset your case for a hearing. Ms. French, do you anticipate that you would try to get anyone from the county to prove those allegations of 7 and 8, or just go forward on what he's pled on?
I think we can go forward on the 10 and split on.
Okay, so then we'll get an updated pre-sentence report done. Anything that you think is important for me to know, make sure you get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. All right, and go back with the bailiff. Clifton Keller.
Clifton Keller. Keller. Keller.
Good morning, sir. Are you Clifton Keller?
Yes, ma'am.
And Mr. Keller's case in cause number 25 DCCR 1462, he's charged with arson. His case is set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, before we make that announcement, I have been in contact with Mr. Nichols. The state has made a new offer of 5 years TDC, which my client has rejected, and we are ready for trial.
Okay.
State's ready for trial, Your Honor.
Let me make, so it looks like the previous. So it looks like there was a previous offer that was rejected of, it looks like 15 years in prison, and that's been reduced for an offer today of 5 years. Is that your understanding, Mr. Keller?
Yes, ma'am.
And you want to reject that and have your case go forward with trial next week. Is that correct? All right, we'll get that done. I do want to make sure that after today, I number the cases after this docket. There will not be any other plea agreements after today. Do you understand? Unless there's something that comes up that nobody knows about. So I'll number the case and I'll let the attorneys know after docket. All right, you can go back with the bailiff.
Just like Dave.
I made a new version of that old plea bargain rejection, so I can write that on there. If you need, I don't know if I need to tell you that or not. James Moffett, Mr. Lewis.
Judge, that's been dismissed, or at least I signed dismissal.
Hey, just.
Did I already sign the dismissal? James Moffett, do you say, I'll do that in a minute. That's fine. When did you send it today?
Yes, yes.
I see it, Judge. I'm sorry.
Okay, I'll sign it and Mr. Moffitt's free to go back.
He's in federal custody, Your Honor.
Oh, well, then, never mind. Let's. Did you have anything else?
Had a hearing that was set for 11, Judge.
Oh, okay, all right.
But to be honest with you, we actually worked out an agreement with you, so I'm gonna go with the state, so whenever you're ready to take.
Okay. Perfect, thanks. What did that happen with Mr. Parker's Marvin Watts? Mr. Nichols, on Mr. Parker's had one case on a Marvin Watts. Did we?
I was just looking at that, Judge.
Would y'all send him a message and see where he went?
I believe Mr. Watts has 2 cases. So I think maybe it's kind of a bit confusion if that one's on the one and not the other. But I don't know.
Okay, yeah. Mr. Rojas, Jaden Brantley.
Yeah, I spoke with Mr. Brantley, his grandmother's looking into hiring an attorney. So if we can just give him a regular reset to give him time to do that.
And I'm gonna delete that rejection then.
And if he
He's,
doesn't,
Brantley can go back.
Yes, ma'am.
And what about John McMillan?
that's gonna be a plea finish.
All right. Okay, John McMillan.
John McMillan.
It is Class A.
Yes.
Thank you. Mr. Vasquez, you got Corey Como.
Good morning.
Good morning.
Good morning, Lee.
So you have videos and stuff, right? Yeah. Okay. Oh, it's on that.
I believe he's indicted last month, so I don't think everything's.
You've already made those requests,
Good morning.
Mr. Vasquez.
Yeah, sure. He was indicted, I think, May 6th. I don't think it.
Good morning. Are you Corey Como? And this is 26 DCCR 0826. Mr. Como is charged with the first-degree felony offensive murder. And what is the announcement?
Judge, it's on me at this point that Mr. Vasquez doesn't have paper discovery. It was not part of my file from the onset. I've requested and received it from Beaumont Police this past week, and it's being added to discovery. It's dozens of pages of police reports and stuff like that he doesn't have yet.
Okay.
So we're getting that to him.
And any videos also, I would assume?
There's a lot to voluminous, Judge.
Okay.
He needs to get all of that.
All right, so what I'm going to do is just do a normal reset, about 30 days or so. We'll see where we are at that time. Hopefully, Mr. Vasquez will at least have everything. And then if there needs to be some more time at that point to go over it or investigate, we'll talk about it then. All right, so he'll be out to see you as soon as he gets all of that information. All right, you can go back with the bailiff.
Thank you, Your Honor.
And then Raymond Sweet.
You know, when I talk to you.
Is he back in his office?
To the detective.
Just reset it a week.
I want. Okay.
I don't know if, we're gonna reset Mr. Watts just a week. I think there was some miscommunication on, with Mr. Parker on that one. Okay, you are Raymond Sweet. And Mr. Sweet's case in cause number 25 DCCR 1531 is set for trial to begin with jury selection next Monday. And what is the announcement?
Your Honor, Mr. Sweet has rejected a 25-year offer and a offer of a 30-year cap.
Okay.
And we're ready for trial.
State ready?
State's ready.
All right, so Mr. Sweet, I've got a new plea bargain rejection. I don't know, I can't remember if it's different, but anyway, it looks like there was a 25-year offer or a cap of 30 years, and we've gone through that before. And your indictment, which alleges at least 2 prior convictions, and that if you are found guilty and those convictions are true, the range of punishment would be between 25 years minimum up to 99 years or life. You understand all of that?
Yes.
All right, then I will number the cases as soon as docket's over, and Mr. Vasquez will be given that trial order for next week. All right, you can go back with the bailiff.
Thank you, Judge.
Thank you. On Ms. Holmes, are you ready on the Asia's Clemens?
Yes, sir.
Okay.
Yeah, give us.
We've got, you have worked out with Mr. Kimler, agreements in both cases,
Yes.
correct?
I'm not sure, did Mr. Cameron do it? Discover? Yes, sir. Okay.
Let's see, this is, Ms. Malfino's on Ms. Clemens. And you got the other.
Courtrooms aren't just places where people are sentenced. They're places where futures are decided. In this case, the judge chose accountability with opportunity instead of immediate prison. Now the next chapter depends entirely on one person, the defendant. Will he use this second chance to rebuild his life? Or will he be back before the same judge facing a much harsher outcome? Let us know what you think in the comments. And if you enjoy real courtroom breakdowns like this, don't forget to like, subscribe, and turn on notifications so you never miss the next case.